Almost there.
Okay, and maybe I could
And
introduce Michael just one more time for the video. So
uh yeah, we
yeah, sorry.
are live right now. Okay. Thank you. And yep, take it away, guys.
Yeah. So Michael Grinthal, our presenter for this workshop on good cause eviction, he's the director of housing rights at Take Root Justice and has been a tenant lawyer since 2007 here in New York City and has done a lot of work to bring legal service and organizing, tenant organizing together. So yeah, please take it away, Michael.
Thank you so much, Sarah and Nipa. And I also want to say for everybody, our hosts are very well versed in this as well. And Sarah uh, has played a role in passing the good cause eviction law, knows probably more than I do about the good cause eviction law. So I'm honored to get to be here and talk about it. I also see in the chat that there are a lot of people here from different organizations. If you haven't already, please put your name and where you're calling in from, if it's an organization or if you're a tenant and you feel comfortable, you could say what neighborhood you live in. I'm just going to share my screen. Okay. And hopefully everybody can see that. If you can see that, please give a thumbs up. All right, great. All right, so today we're going to be talking about the good cause eviction law that passed the state legislature a year ago. Again, I'm Michael Grinthal from Take Root Justice. Take Root Justice is a nonprofit legal services provider that provides legal participatory research and policy support to grassroots and community-based groups that are fighting against racial, economic, and social oppression. And we are uh, glad that we often get to work with Housing Court Answers and with a number of the organizations that I see in the chat. So today we're going to get into the basics of the good cause law. So first, what does it do? Then who does it cover? When it took effect? And then how we can help others in our communities take advantage of the good cause law. In the meantime, if you have questions as I'm talking, please drop them in the chat. Sarah will keep an eye on that. And if it's a clarifying question, she'll give me a nudge so that I can clarify as I go. If it's a question um, to wait until the end, then she'll keep track of those and we will get to them at the end. Great. Okay. So what does the good cause eviction law do? Basically, it does two things. It prohibits no cause evictions. In other words, evictions that happen just because a landlord says, I don't feel like renting to you anymore. And two, it limits rent increases when you do get a renewal lease. So evictions only for good cause means that the landlord has to point to something that either that the tenant has done wrong or a special need that the landlord has for the property. And this is very close. It's based on the causes for eviction under the rent stabilization code. So people who have dealt with rent stabilization, this should look familiar. These are some of the reasons that a landlord can evict a tenant under the good cause law. If the tenant breaches a provision in their lease, if they commit a nuisance, if they use their apartment for illegal activities, or they use the apartment for something other than residential purposes, like they turn it into a business or a factory. Um, if they deny the landlord access for repairs or an inspection, if the owner wants to recover the apartment for personal use, and that means to be the primary residence of the owner or someone in their family. So they have to actually be moving someone in their family in to live there as their main place of residence. Um, if they're going to demolish the building or turn it to a different use, and if the tenant doesn't pay rent. So that's basically the causes, and again, very similar to the causes under the rent stabilization law. As for limiting rent increases, the law says that when a landlord renews a lease, they can raise the rent by 5% plus the annual change in urban consumer price index, which, of course, we're all used to chatting with our friends and family about the annual change in urban consumer price index. So we all know exactly what that is and how to find it, and we can move on. Um, no, the annual change in urban consumer price index is a long way of saying the inflation rate in cities over the last year. The federal government calculates that, but for us, the state Division of Housing and Community Renewal, DHCR, the same agency that oversees rent stable federal government, and publish it on their website. And they started doing that last year. For last year, and I believe still, though it may be changing soon because we're at the 1 year anniversary of the law, the inflation from 2023 to 24 was 3.82%, right? So you look up that number, you add it to five, and what you come out to is 8.82%. That's the supposed to be the maximum rent increase that a landlord can give in a renewal lease during that year. That is a pretty high number. The numbers for rent stabilization uh, vary each year, but for a 1 year lease, they're usually between 0 and 2.5%. And for 2 year renewals, they're usually between 2 to 6%. So this is much higher than either of those.
Um, and maybe just a thing to add to this is that, and tell me if I'm wrong, Michael, but there's like inflation can get really big, right? And we've seen a lot of inflation in the recent years, but there is a maximum of 10%, right? So if
Yes.
the CPI is 10%, could it be 5 plus 10? I think not. It would be just 10% is
But
the ceiling, right?
yes, the what they call the when they add those two numbers together, it's called the local rent standard. And yeah, thank you for reminding me. That's capped at 10%. Although neither of those numbers is a hard limit, as we're going to find out as we move through the training. So the law says that the landlord can't increase the rent by more than that local rent standard, that 5% plus inflation, except the landlord can raise the rent higher than that based on unusual costs that they have. And the law lists some of the things that could be considered unusual costs: fuel and utility costs, insurance, maintenance, significant repairs, which could mean replacing a building system or abating lead or asbestos or mold. Um, and so this puts the tenants in a very difficult position because a landlord can give a tenant a renewal lease with an increase of more than the 8.8% and say, well, it's because I had unusual expenses this past year. And if the tenant and the landlord disagree about that, if the tenant says, well, I don't believe you, or I don't think your expenses were so high as to justify a big rent increase, there's no way for them to resolve that argument except to go to housing court. If you're familiar with rent stabilization, when a landlord and tenant disagree about something under rent stabilization, they can go to the state agency, DHCR. They can file complaints, and DHCR can make a decision on those. And DHCR moves kind of slowly, but it's very easy to do, and you do it on paper, and you don't have to risk getting evicted. But there is no agency for the good cause law. DHCR doesn't handle complaints or matters under the good cause law. So the way the law is written is if your landlord gives you a renewal lease with a rent increase of 15% and says, it was a rough year for me. I had to pay for a lot of stuff. And you say, I don't want to pay that much. About the only thing you can do is refuse to sign the lease, wait for the landlord to take you to housing court for eviction, and then in your defense, raise this issue. And then a judge will decide uh, whether the landlord's rent increase is justified. Um, and that's obviously a very dangerous way to get in an argument because it involves being taken to court. If something goes wrong, people who are taken to court can be evicted. Even in the best of circumstances, going to court is difficult. It's anxiety producing. It takes up a lot of time. You miss work or you need to get a lawyer. Um, and on top of that, the law doesn't actually give judges any direction on how to decide whether a rent increase is justified. It doesn't give them any directions except basically what you see here on this slide. It just says you can consider these things. It doesn't say how to consider them. It doesn't give them a calculation. And so it's very unpredictable, at least so far, about how judges are going to treat these rent increases that go above the local rent standard. And we haven't had much opportunity to see judges rule on this yet. So we still don't know how they're going to do it.
So if, with a lot of non-payment cases, when repairs come into play, a tenant can often say, I shouldn't owe the entire amount because the landlord was failing to make repairs. And so I'm wondering if when the landlord says, I needed to do mold remediation, is a tenant allowed to say, well, the mold was caused by your failure to repair a leak?
Mhm.
Could fights like that happen in the courtroom?
Yeah, they could. I think, but the problem is we don't know how they'll come out in front of
Mm.
judges. It makes a lot of sense. What you're saying makes a lot of sense as a legal argument to say if the landlord allows conditions to get bad, to get especially bad by neglecting them, and then it's expensive to fix them, but it's really the landlord's fault because they could have fixed it cheaper a long time ago. Should they be able to be rewarded for that? Um, I think if you make that argument in housing court, judges will recognize that. It's a lot like other arguments you can make in other situations in housing court. And it's a common sense and common decency argument. But we still don't know how it's going to play out. And I have not talked to any judges about this, but I would not be surprised if they also, at least secretly, are pretty annoyed by this because it gives them no directions on how to rule. And judges like to have something that makes their decisions clear. And this definitely does not do that.
Mm.
And just a clarifying point, when you say it has to be dealt with in court, at least for housing court, the landlord has to take the tenant to court for non-payment. It can't be the tenant doing anything in housing court.
Correct. Yes. And in fact, what it wouldn't be for non-payment, it would be that the tenant doesn't sign the lease because it has what they view as an illegal rent increase. And then the landlord takes you to court for not signing the lease.
Thank you.
Holdover cases are so much scarier.
Yeah. So, I should have said before, this is going to come up throughout this training, is that there's still a lot we don't know. There are definitely pieces of the law that look like they were put together by a committee in the middle of the night right before the law was voted on, and that's because Sarah, I think, back is that's pretty much exactly what happened, um, which is true for most laws, but and some of it is also just because even a very clear law, you don't really know how it's going to play out until you've seen judges rule on it. So there are a lot of question marks here. Maybe a more optimistic way of looking at that is there are also a lot of opportunities for us to fight to get good law on this and get judges to interpret things in ways that are supportive of tenants and affordable housing. So that covers what the good cause law does. Now the question is who is covered? And that is also complicated. Um, but to start with, if you live, if your landlord owns more than 10 housing units in New York State, doesn't have to be in the same building, it could be 10 single family homes, um, then you are probably covered by the good cause law. Now, how do you count how many units your landlord owns? Um, it gets difficult because most apartment buildings are not owned by an individual person in their own name. When a landlord buys a building, they usually form an LLC, a corporation, to own the building. So that if somebody falls down the stairs and they get sued, you're not suing your landlord personally, you're suing the company, which might mean that there's one person who has 20 LLCs that own 20 different buildings around the state. And there's no place that you can look up to see who is the person behind an LLC. But when you're counting the number of units that a landlord owns, it includes everything that that person owns. If your building is owned by an LLC, then any people behind the LLC, which we call beneficial owners, right? The people who benefit from the LLC, you can count any other buildings they own anywhere else in the state, as well as any other buildings owned by any other LLCs that they own. Um, and this can turn into a very complicated map, right? Some landlords uh, may own 30, 40 buildings through any number of LLCs that are interlocking and complex to follow. Um, so this is a major area where, tenants have to do a lot of work and we have to help each other do this work because it takes a lot of detective work to figure out how many units your landlord owns in the state. Now, if there's more than 10 units in your building, great. You have a very simple answer. Obviously, they own more than 10 units. But for those who live in smaller buildings, you live in a 6 unit building and you want to know whether your landlord owns 4 other units elsewhere, um, we will get into later on what kinds of resources there are online to look up ownership of buildings to try to see where different names reoccur and might be connected to other buildings. This is called the small property owner exemption. So in other words, if a landlord owns, 10 or fewer units, they're not covered by good cause. If your landlord is going to say that they come under that exemption, that good cause doesn't cover you or them because they own 10 or fewer units, then anytime they renew your lease or send you a notice saying they're not going to renew your lease, they have to put in a notice saying you're not covered by good cause and here's why. Also, if they ever take you to court. or if they serve you any notices to get ready to take you to court, they have to put that notice in. You're not covered by good cause, and here's why. So at least you are on notice of the reason, which exemption they're claiming, and the reason that they're claiming they're not covered. Now, they're not going to give you a list of all the units they own in the state. And even if they did give you a list, it would be hard to trust because, they have a strong incentive not to count the units in Rochester that are owned by an LLC that's owned by an LLC that's owned by an LLC that's owned by their brother. So, but that is the starting point. If you're trying to determine whether you're covered by good cause, is the notice that the landlord gives you, at least tells you what position they're taking. There are some other exemptions, and these are probably easier to follow because for the most part, um, if you're already covered by some other law that's already providing these kinds of benefits, then you're not covered by good cause. So if you're rent stabilized or you're rent controlled, then you're not also covered by good cause. And in fact, rent stabilization and rent control give more protections than good cause. So it would actually be a step down if you were moving to good cause. Uh, Good cause also doesn't apply to most subsidized kinds of housing like Mitchell-Lama or project-based Section 8 or low-income housing tax credit. And again, those buildings have their own protections, their own limits on rent increases, and their own um, prohibitions against evicting people without cause. Other kinds of housing units that are not covered by good cause are sublets. So if you're a subletter, you're not covered by good cause. The tenant you're subletting from might be, but you as a subletter are not. You can be evicted without cause. Units in co-op or condo buildings. And that's not just the condo and co-op units. So if you're in a rental unit that's in a co-op, because usually in a co-op there are a few rental units left from before the conversion, you're not covered by good cause. Same with condo buildings. And then just because the people who wrote this law really like mathematical formulas, also you're not covered if the rent is over 245% of fair market rent, um, which requires looking up more charts and tables produced by HUD and the federal government. Just as a ballpark, when good cause passed last year, that would have been $6,005 for a one-bedroom apartment. Um, so
A lot.
pretty, yeah. I don't know about you all. I mean, I won't ask for a show of hands, but that's not what my rent is. Um, and then here's the really big exemption. Good cause eviction law does not apply to any housing unit where the certificate of occupancy was issued after 2009. And let me take a step back and say and talk about what a certificate of occupancy is. When a building is built, a housing building is built, or when it's significantly renovated, Department of Buildings has to inspect it and make sure that it is up to code and habitable and safe. And when they do that, they issue a certificate of occupancy that says, yes, the way this building is built complies with the building code. And the certificate of occupancy will list how many units of which kinds are in the building. And if you're curious, uh, most certificates of occupancy are actually scanned, and you can get them online at the Department of Buildings website by searching for your address. Um, so this means, first of all, any building built after 2009 is not going to be covered by good cause. But it also means that any building where basically like the number of units or the kinds of units is changed, where there's been a major renovation since 2009, also won't be covered by good cause. So if you're covered by good cause today, but then after you move out, your landlord combines your apartment with the one next door to get a new layout, a new housing unit, and they have to get a new certificate of occupancy, no more covered by good cause. So, in short, the way to think about it is this doesn't cover new buildings. It doesn't cover buildings built since 2009. And it does give landlords some incentive to make big renovations in their buildings to try to avoid good cause. And that may sound familiar to folks because there's similar incentives under rent stabilization. And that's been a fight for years, right? Landlords trying to find ways around these laws by changing the number of units in their buildings, changing the layouts, getting new certificates of occupancy.
Um, that is so frustrating.
Hmm.
But I wanted to go back to the co-op and condo segment
Mhm.
because what if a landlord owns um, 20 condo units throughout the state?
Mhm.
Those condo units, can they be included in the count of, because I mean, the whole small landlord versus big landlord, it's this 10 versus 11 plus.
Yeah. When you're counting units to see if your landlord has more than 10, any housing unit, right? So if they own a condo somewhere, if they own a single family house somewhere, if they own an SRO somewhere, any kind of housing unit counts.
Okay.
Even if they own a housing unit that itself wouldn't be covered by good cause, it still counts when you're counting up the number of units to see if they're a big or a small landlord.
Okay.
Yeah.
Yeah, a lot to take in. Mhm.
Yeah, there are a lot of moving parts here, and there are a lot of opportunities here. There are a lot of powerful things here that give tenants tools to fight back. Um, but it's a big learning curve for all of us to learn how to use these.
Oh, and one more thing, the certificate of occupancy thing, I feel like I remember that that was sort of a rolling number that like 2009 was the date, the cutoff date when the law was passed. But is that date going to, is there like a rolling over?
That's a
Um,
good question. I had not heard that. It would be great if it were true. So let me look that up after we're done here and I can let you know.
okay, thank you.
Yeah. So when did the good cause eviction law take effect, right? When were landlords required to do these things? It was passed a year ago, and so the first day that it took effect was April 20th, 2024. And that means that any renewal lease that a landlord offered, actually any renewal lease that took effect, right, where the lease start date was after April 20th last year, is covered by good cause. Even if they had sent the lease earlier, if as long as the lease was going to start after April 20th. So most leases, that's the first of the month. So May 1st, 2024, leases from then on covered by good cause, which means they had to have been they had to have included a rent increase of less than 8.8% or an argument that there were unusual extraordinary costs. And under that lease, you can't be evicted except for cause. There was one more provision that took a few months before it kicked in, and that was, if you remember, I said that when a landlord gives you a new lease or says they're not going to renew your lease or takes you to court, they have to give you a notice that tells you whether you're covered by good cause or not, and if you're not, why not. So anyway, that requirement didn't kick in until August 20th of last year. But everything about the law is now in effect. Okay. So there's a lot here. Um, and there's a lot for us to do. There's a lot for us to figure out. There's a long way to go so that we and our communities can make the most of this law. And there's a lot of people out there who are covered by good cause and don't know it. And there are a lot of landlords out there covered by good cause that don't know it. And then there are a lot of landlords covered by good cause that know it, but hope their tenants don't know it. So there's a lot for us all to do. And I do want to say a major shout out to the tenant movement, to Housing Justice for All, to the Right to Counsel Coalition, and to a lot of the organizations that are on this call, to Sarah and all the other tenant leaders. This, even though there's a lot about this that may frustrate us, this is the biggest change to housing law and tenants' rights in New York State, arguably since the 80s. This is it is not everything that the tenant movement wanted, but it is a huge step forward for many, many tenants if we make the most of it. So what can we do, right? Um, we can research our own landlords, determine whether we are covered by good cause. We can teach our neighbors, uh, other people in our organizations, our clients, if we have clients, about how the law works. We can help each other research our landlords, because remember, again, a big piece of this is the detective work of figuring out how many housing units our landlords own. And then finally, asserting our rights, because some landlords, maybe a lot of landlords, will do the right thing, but some, and maybe a lot, won't. And it'll be up to the tenant to say, hey, wait a second, this rent increase is higher than you're allowed to charge me under the good cause eviction law. Or, hey, you can't take me to court for no reason because I'm covered by good cause. Right? So here are some of the areas where we expect there to be struggle. You're probably all thinking the same things. Um, there's going to be disagreement about the number of units actually owned by owners, right? We can't rely on landlords to give accurate counts of this. We can't even really rely on landlords to understand the law well enough to make accurate counts, even if they are honest. We know that landlords are going to make heavy use of that significant repairs clause, the one that allows them to get a higher rent increase. We know that since there's no real rules around that, landlords are going to try to get away with the most that they can get away with and see where the court puts boundaries on it. And so there's really no way that that's going to get worked out except through tenants and landlords struggling and getting in disputes over these things. And again, as we mentioned, landlords now have a big incentive to get a new certificate of occupancy by doing significant renovations to their buildings. So I'm going to finish by talking about what are some of the resources we have in doing that detective work. And then hopefully we'll have time for, and I think we're doing pretty well on time, right, Sarah?
We're
Yeah.
doing awesome.
Okay, so we'll have time both for questions and also discussion because I am really curious to hear what people are experiencing out there, whether you are covered by good cause, whether your landlord has done anything around good cause, either following it or not following it, whether people in your community are talking about good cause. There's a lot going on out there, and the only way we're going to get the big picture is by all sharing our stories with each other. But before we get to that, these are some of the most important resources that we have in doing the detective work to find out how many units our landlord owns. So I'm not going to go in order here. I'm going to start with the second one, ACRIS. If people haven't used this, ACRIS is where anytime a building gets bought or sold, the deed has to be reported to the clerk, the county clerk, who scans it and uploads it. And so every sale, every purchase of a building in New York City is on this website called ACRIS. And you can look it up by address. And you'll see the whole history of the building, um, every time it's been bought and sold, every mortgage on it, and a number of other things, like if they have a government agreement on it. And what's especially useful about this is you can also search by name. So you can search by the name of a company or a person to see which properties their name comes up on. So that should always be the first stop in doing the research. It won't be the last stop because again, you may not know all the different LLC names that your landlord owns other buildings under. But you can at least find out all the buildings, all the properties that they own under the name you know, right? Either their personal name or their LLC name. There's also an excellent tool developed by a nonprofit organization called JustFix, called Who Owns What. And they gather data from all kinds of different databases that the city has. And they put it all together, and you can enter your address, or you can enter the name of a landlord or the name of a company, and it'll give you basically every property that has any kind of relationship to those names. Um, so it'll give you a long list. That list isn't necessarily every building your landlord owns. It could be buildings they owned in the past and don't own now. Could be buildings um, that they have some other involvement in, like they provide management services at that building, but they don't own it. Um, could be another landlord with the same name, right? So it gives you something to work with. It'll give you a bunch of addresses. It gives it to you in a nice, friendly format with a map showing where all the buildings are. And then you can take that and run with that, right? You can then look at the website that's the first bullet point here, HPD Online. HPD is, among other things, the code enforcement agency for New York City. You can look up any multiple dwelling. That means any building with 3 or more housing units in it has to be registered with the city. You can look it up and you can see all kinds of information about the building, the number of apartments in it, the name of the landlord, the name of the super even, and any code violations, that's not directly relevant to us today, but it is an important piece of info. So you can take all of the addresses that popped up in Who Owns What, and you can enter them into HPD's website and see if, yes, the current owner actually is your landlord. Or, maybe another landlord's name comes up, and unfortunately, that's not a building owned by your landlord. You can also, if you're trying to find out more information about a corporation, an LLC, or some other kind of company that owns your building, the New York Secretary of State has its own database where you can look up corporate names, and it'll tell you some information like when it was incorporated, what its mailing address is, uh, whether it's still a corporation or whether it's been dissolved. Unfortunately, for LLCs, which is the kind of corporation that landlords usually use, it won't give you any more information than that. If you look up an ordinary corporation like AT&T, you can find out all kinds of information about their board of directors and who owns the stock. But for an LLC, you don't find that out. The names of the individual real people behind it who own it, they're not public. You can't find it out by looking it up in the Secretary of State database, but you can at least find out what is the mailing address and who's the contact person for the LLC? And sometimes you can use that to see, oh, look, these 5 LLCs all have exactly the same mailing address and the same contact person. I have a feeling that they're all owned by the same person. And I'll say one last thing. A little over a year and a half ago, New York passed a law, New York State passed a law requiring all LLCs to submit, to register with the state government, the names of those people who own them, the names of the real people behind them. And the state will start keeping a database of those actual names. Couple things. First of all, that doesn't start until January 2026. And 6 months after the law passed that law, after the state passed that law, they passed another law that said the corporation database won't be available to the public. Only the government can look at it. You and I can't look at it. Um, but all is not lost. This can still be useful to us because there are some exceptions to that. A judge can order something disclosed from the database. So the long and short of it is if you're in housing court, you can do a subpoena and you can see what's in the database that way. Also, some agencies have the right to look at it. The Attorney General's office has the right to look at it. I'm not sure, but DHCR might. And so those are agencies where there might be officials who are friendly to the tenant movement, who may be willing to try to help us see what's in the database or at least get answers out of it about particular landlords. And that's another thing that, is work for us all to do over the next year, right? Is building up allies who can help us look things up because that database, if we can get access to it, that's magic, right? We can erase all of these websites here and just go straight to that. Throw in the name of the LLC that owns your building, do a couple of searches, and you'd have your answer for every housing unit that they own.
So you said that the government has access to this the LLC database.
Mhm.
Um, would elected officials have access to it? Like if people needed this information, could they go to their city council member, their
Uh,
state legislators?
that's a great question. And I don't remember. I'm sorry. That's another thing I can look up and get back to you. I have somewhere a list of all of the different government actors that can have access to the database.
And maybe if
And
people were
I'll
maybe
get
if people were asking their elected officials over and over for this, they might be
that.
inspired to pass a new law saying, you know what, let's
Yeah.
just make it publicly available.
Yeah. Yeah. Yeah.
Um,
So that's what I got. Um, and I'm interested to hear what all of you got. Starting with questions, but
uh,
also interested to hear people's experiences, news that you've heard about the good cause eviction law, anything. Yeah, we need to share information with each other as much as we can.
yeah. So before I start reading off some of the questions, I just also Just Fix, who created the Who Owns What database, they also have a new tool. I put the link into the chat along with Michael's links from the slideshow. It says goodcausenyc.org. So that's another thing that people can use when you're not really sure which one of those websites to go to first. You're just not sure. You can start with that new tool as well, and it will probably take you to those other links. Um, so, okay, going back to questions. Um, okay, we have a question. So the failure to pay rent, um, let's see, what is to be done when the payment portal is blocked and certified mail with the rent check is not accepted? Um, Yeah, because in a way, it's not like the tenant is choosing not to pay rent. It's that the
Yeah,
landlord's choosing not to accept it.
yeah. And that's me the same whether you're covered by good cause or rent stabilization or nothing at all. Um, if the landlord is not providing you with a way that you can actually pay rent, first, obviously, any way you have to communicate with the landlord and tell them this is not working. Um, First of all, they may fix it. Second of all, if they don't, at least you're creating a paper trail, showing that the landlord knew. If there's just no actual way that you can get rent to your landlord in a way that they'll accept, uh, my advice would be to set the rent aside. You know, not being able to pay it that month doesn't waive the rent. You still owe it. So set it aside. But again, make a paper trail to, showing the landlord either not accepting the rent or not taking the steps necessary to fix things so that you can pay the rent. So that if they do take you to housing court, you can show, exactly what happened. You can also make a non-payment case go away instantly by paying the rent, right? So if worst came to worst and they take you to housing court saying you didn't pay, um, and you say, well, I've got a money order right here, that'll be the end of the case.
Yeah, thank you. Um, and another one related to rent, can the landlord increase the rent by 3% every month if they are a month-to-month tenant? Um, because yeah, those increase limits, does the language of the law get clear about yeah, like
I
what
believe if
the
you're, I believe if you're covered by good cause, you're entitled to at least a 1-year lease. So you don't have to be a month-to-month tenant. Um, if you nevertheless are a month-to-month tenant, if you'd rather be a month-to-month tenant, that's a good question. The law's not clear on whether the landlord can do some kind of calculation where they give you like 1/12 of the increase each month, or whether they can only increase your rent every 12 months. I don't, I think that is something that a judge would have to decide because I don't think the law addresses that possibility. But they certainly can't do the, 8.8% every month. That is very clearly that is an annual increase.
okay, good. I'm glad that it's clear. I just thought, oh, did somebody discover a whole new loophole? Wow. All right. Here's another question. If a tenant's last lease was rent stabilized, then J51 expired and the new lease is market rate or unregulated, is the maximum allowed percentage increase still calculated off of the last rent stabilized amount?
So if I'm understanding it right, um, you have a rent stabilized lease with a certain rent covered by, determined by rent stabilization. Then the J51 benefit runs out, so the landlord is giving you a renewal lease that's not rent stabilized. If you're covered by good cause, then yes, the new lease has to take your current rent, right? The rent under the lease that's expiring as the basis, and then do 8.8% on top of that. And I shouldn't keep saying 8.8% because I think it's about to change to whatever the new number is, but I'll use 8.8% as the stand-in here. So they take as the base what your current rent is.
And that question from the participant, it actually brings up something that it can be an actual, a really powerful thing about good cause is that, we all know that rent stabilization is tougher protections. It's stronger, more robust protections than good cause. But a lot of rent stabilized units were lost since the 1990s with vacancy decontrol. And so, and sometimes the deregulation of an apartment was following the law and done legally, and sometimes it was not. And sometimes tenants want to, if a tenant believes that they should have received a rent stabilized lease, but what they got instead was an unregulated lease, if that tenant is covered by good cause, then it gives them a little bit of security when they try to deal with this pretty thorny and difficult issue. It could, yeah, because a person could be very afraid to pick that sort of fight, even when a lawyer has told them, oh, you've got a great case here. Um, it's just hard. But so, in a way, good cause can help with that organizing, the same way that it can help. And in fact, Housing Justice for All at a certain point was talking about the good cause bill as the right to organize, because unregulated tenants are so frequently afraid to call 311 when there are repairs. They're afraid to organize with their neighbors around repairs if they think, well, is complaining going to lead to me not being offered a renewal lease? So, um, yeah, it's something that I wanted to just highlight in terms of, what good cause can give us in terms of power.
That's an excellent point. And, you know, uh, we at Tigger, we were working with a group of rent strikers in East Harlem. We've been on rent strike for 2 years. There are two tenants in the building that are not rent stabilized. Everyone else is stabilized. Those two tenants had to be very careful about how they participated in the tenant organizing, because their landlord could just say, I don't like you anymore. I'm not giving you a renewal lease. And a year ago, literally the day after good cause passed, we were able to tell them, you're safe now. You can stick your neck out. You can come to the tenant meetings. You can join the rent strike. Your landlord can't refuse to renew your lease. Made it, right away, it made a huge difference.
Yeah. Um, okay. I see one question that might actually be about a rent stabilized apartment. So we might just hold off on that for a second. Um, let's see. Oh, so a next question. Okay, so Evelyn's question, it's about a rent stabilized, because rent stabilized apartments are not covered by good cause because they already have better protections. Maybe we'll just hold off that question until we get through the good cause questions. But thank you for it. Let's see. Landlords are supposedly required to include notice of eligibility or exemption from good cause protection in lease. If landlord fails to include that notice, are there legal ramifications for them?
Yes, I believe that they're, if they don't include that notice, then they're not considered to have sent you a valid lease renewal. And so you would not have to sign that lease. That might not, in practice, be the best thing for you to do. It would depend in your circumstances whether getting that notice is really important to you, whether you're having other disputes for your landlord and how it fits into that. But that would be the legal ramification. There's no ramification of like them having to pay a fine or anything like that. It's just that the lease renewal is not proper if they don't include that. And also if they're sending you a notice of non-renewal, right? In New York, it was already the law since 2019 that the landlord is not going to renew your lease. They have to give you a notice a certain number of months in advance. Um, and now that notice has to also stay, you're not covered by good cause. And here's why. So if they don't include that notice with that, and this gets a little involved, it means they haven't given you the proper notice of non-renewal and they actually can't evict you until they give you that notice. So it can that might take us down another rabbit hole, but um, if they fail to provide that notice, it can actually delay their ability to bring a housing court case for eviction.
And are judges enforcing that rule currently?
Um,
Like dismissing cases because, oh, you failed to provide the good cause notice.
Hard to tell. We just haven't seen enough cases yet, right? Because a lot of these, the lease renewals might be starting in the last, in 6 months, and then there's there's an argument between the landlord and tenant, and then the landlord finally takes the tenant to court, and it takes months to move forward. So I've seen very few decisions at all about good cause so far. I know there are people on this call who are tenant advocates or tenant lawyers, and I definitely welcome folks piping up if you've seen these things or you know the answer where I don't.
Thank you. Okay, and another question. It is my understanding that a landlord has two ways of evicting a tenant, non-payment or holdover case. Holdover cases are for reasons not related to payment or beyond them. Can't landlords just take out holdover cases?
Yeah. So um, I may not be getting to everything that's in your question, so let me know if I'm missing. But this actually goes right to what the good cause law is about. Um, that the landlord can bring a holdover, but they've got to have a cause. There's got to be either some wrongdoing from the tenant, you breached your lease, you committed a nuisance, um, or one of the other reasons, like the landlord is going to demolish the building or move their family into the apartment. What they can't do anymore is just say, I'm not renewing your lease and I don't have a reason, and I don't have to have a reason, right? That's what good cause means. They've got to have a cause, and I guess it's got to be good.
Um, this is also reminding me that the non-payment of rent as a reason, as one of the good causes allowing for a holdover. Um, I I'm maybe I'm jumping the queue, but when sometimes tenants go on rent strike because they're trying to get repairs or deal with something difficult uh, within a building. And so when the person has gone on rent strike but is able to pay within that holdover case, like does the non-payment of rent reason still hold up within the holdover case?
If the person pays,
Yeah, like if the landlord starts a case against a tenant, and their good cause is non-payment of rent, can the tenant, um, pay that rent in
yes.
order to like make the case go away?
Yes.
Okay.
Yeah. They can't do an end run by saying, I'm suing you for not paying rent, but this isn't a non-payment. So yeah, that doesn't work. If you get taken to court and the only basis for you facing eviction is non-payment and you pay, the case is over. The-
But would they be able to have a dispute about abatements? I mean, could a person go to trial and say, well, I want an abatement. I don't want to pay
Mhm.
100% of that.
Yes, they
Okay.
could. If you have conditions that you think you should get a rent abatement for, yes, you can raise those. You can raise that as a defense and a counterclaim in your housing court case.
Okay. Um, so another question from a volunteer with the Met Council hotline, very cool, is since not signing the lease means going to court, which could be risky, what are some strategies to try to negotiate with the landlord and try to enforce good cause before you go to court?
Very good question. And I'm gonna give my answer, and I'm gonna invite and encourage others to give their answers as well. Because this is partly a lawyer question, but it's also partly an activist question, an advocate question, an organizer question, a grandma question, you know. So the first thing to do, and probably the first thing you would think of, is in writing, respond to the landlord and say, under good cause, you know, I'm covered by good cause, and here's why, and here's the housing units you own that I've found. And so the lease that you sent me doesn't comply with good cause. You know, you can't raise the rent above this amount. Um, if they don't listen to that, right, or they write back saying, oh, but you know, we had to abate some mold this year, so we can raise your rent by 1,000,000%. Um, then I would push back and say, tell me where you spent this money, you know, tell me what you spent it on, give me the documentation. Um, I would also reach out to my neighbors and talk to them and see what kind of how the landlord's treating them. First of all, if the landlord's treating them differently, then there could be the landlord could be committing discrimination, or maybe what the landlord is telling you isn't true if they're telling others something different. Or if they're telling every tenant, yeah, I'm gonna raise your rent by 1,000,000%, then maybe you've got something to get together and fight for together. And no matter how you fight, whether it's in court or whether it's out of court, you're always more powerful with other people. But I'd be interested to hear what other people think about that, especially if there's anybody here who's actually been in that situation and gotten into that fight.
Yeah, so if people wanted to tell us about any involvement they've had with this side of things, please feel free to pop it into the chat. Um, yeah, and you know, I'm thinking about, I mean, with housing court answers, we help small landlords fill out forms all the time, especially the good cause notice, and they often look at this 6-page packet. They're very confused, but we try to explain things. But you know, sometimes even just the officialness of sending the letter um, by certified mail, maybe attaching some articles that explain all of this. You know, if the situation is the landlord is a small one that's just kind of shooting from the hip, sometimes just, you know, speaking from a confident place and trying to do things in a way that looks official can sometimes make them think twice about, you know, pushing this thing all the way to go to court.
Mhm.
Um,
Absolutely.
yeah. Uh, let's see. So until we have more thoughts on that, there's another question. It's okay. So it's a little bit of a throwback. In 2019, the law changed that said if a landlord wants to raise rent more than 5%, they have to give advance notice of this, you know, 90-day notice for either non-renewal or raising it above 5%. Um, uh, oh, and Tabitha asked if she can ask absolutely put the question into the chat, and that's exactly the way to go. So this question is so for a tenancy in excess of 2 years in a good cause apartment unit, if the 90-day notice about non-renewal or raising the rent above 5% is not observed, um, has the landlord waived their right for the non-renewal or not raising the rent above 5%?
Um, so please let me know if I'm misinterpreting the question, but I think what I'm hearing is, well, let me take a step back. What's being referred to here, the 90-day notice, um, when you're not rent stabilized, when you're not covered, when the landlord's not going to renew your lease, they have to tell you before your lease runs out, they have to give you a notice, either 30 days in advance, 60 days in advance, or 90 days in advance. And which one depends on how long you've lived there. If you live there for 2 years or more, they have to give you a 90-day notice saying, I'm not going to renew your lease. And that's not part of good cause. That was part of the rent laws that were passed in 2019. Um, it, Under those rent laws, if the landlord doesn't serve you that notice, right? They're supposed to serve it 90 days before your lease expires. If they miss that date, they can still serve the 90-day notice. They just have to still wait 90 days, right? So they may have to kind of extend your lease term more or less. Um, but they haven't missed their chance. It's not like because they missed the date, they have to renew the lease, right? So that really just kind of pushes, if they don't serve that 90-day notice, they're just kind of pushing back how much time um, before they can bring an eviction case. And I'm not sure if I'm getting to everything in your question because I see some of the things there um, that I'm having a little trouble seeing what the situation is. Um, Sarah, would it
Yeah.
be possible for someone to unmute and just ask their question? Maybe we could do it.
So I think I think you actually answered it, right? Like if the lease expires, it's kind of like your month to month. Um, and yeah, I mean they just need to give a they need to actually give the notice that says I'm going to raise your rent, and they just have to get the timing right after
Right.
that. Yeah. And I want to get to this next question. Um, about good cause and fraud. What if the landlord is lying about their good cause claims on their holdover pleading using good cause?
Um, if you can prove they're lying, then you'll probably win your case, for one thing. Um, Unfortunately, I don't think there's anything built into the law that says like there's a penalty you have to pay for lying. There is, I mean, when you lie to a court, courts will sometimes sanction you, which, make you pay money. Um, that doesn't happen very often, and it's often difficult to prove that the landlord is lying rather than just getting things wrong. But yeah, if you have some evidence that your landlord, deliberately lied in a document that they submitted to court, you know, you get your case dismissed, but see if you can get the judge to punish them. Because again, lying to a court, if it's under oath, is perjury, which is literally a crime. And even if it's not under oath, um, courts can, if somebody brings a baseless case based on a lie, the court has the power um, to make them pay you for your time. So, yeah,
Yeah. It would be interesting to see sanctions for the lawyers. And
yeah,
it's always kind of a surprise when that happens, but
yeah. I'll add, anyone here who's been in housing court knows that lying is just another Tuesday. And it takes a lot, really, really bad special conduct for a judge to sit up and do something about it. That's a problem, but it is also just the way things are in housing court.
Yeah. Um, so just I've noticed that a lot of people joined us after the uh, presentation had already started, and maybe after the slideshow. Um, and yeah, so I just want to encourage anybody who is newer to who joined us a little bit late, if you have questions about good cause, or if there is a particular aspect of good cause that you would like us to revisit, please feel free to put it into the chat. Um,
Yeah, I also just want to clarify, anybody who joined us after two, there was a change on the schedule, and you should have all received an email saying the timing had changed. But if you didn't for any reason, I will post the link for the training here on the chat so you can rewatch the video for whatever parts you missed.
yeah, that's why we go live on YouTube so that people can watch the recording after. Yes. Okay. Yeah, and so Tabitha had another question. Um, yeah, Tabitha, if you want to put the question into the chat, totally welcome.
I'm just gonna check if the live stream has any questions.
Oh, thank you.
Um, yeah, I don't see anything so far. Well, I would like, I don't know if if that's something you can answer, Michael, but like, if you know your landlord owns other properties and you don't know the LLC name it might be in, is there a way to find that out?
Um, if you know the address, there are a number of ways to find out. Um, you can go back you can go to the website I mentioned, Acris, which is where all the deeds are scanned and uploaded. You can look up the address and you can see whose name is on the deed. You can go if the building has three or more housing units in it, you can go to HPD's website and you can look up the address there and get the name of the owner that way too. You can also use Just Fix's tool, the Who Owns What, and look up the address there.
And is there any way to find out who owns the LLC? Like if a landlord has a mixture of like properties in an LLC versus individual names?
That, yeah, finding out the names behind an LLC is very difficult. And that's, when we were talking about the LLC Transparency Act that was passed, but then they amended the law so that members of the public, all of us, can't see that database that lists the names behind LLCs. That's the rub of that. That's really a difficult thing. Again, if you're in court, you could do a subpoena, because if a judge signs it, then you can get that information. Um, you may be in touch with an agency that can do it, like the Attorney General's office. I also want to add that database doesn't exist yet. It's not going to exist until 2026 because when they passed the law, they gave time first for the database to be created and also for all the LLCs out there to uh, fill out their information, send it in. So there is no such thing as an LLC database as of today, but they're building one.
Um, We have the follow-up question to the fraud question. If the landlord participated in fraud that I can prove, what types of sanctions could I request?
It depends on what kind of fraud we're talking about and where. If we're still talking about, a landlord was a party in a court case and they lied, right? They submitted something that was a false statement. And you can show that it was a lie and not a mistake. Then you can ask the judge to sanction the landlord, and usually a sanction means that the party being sanctioned has to pay some money, either to the court or to the other party, or maybe both. And if you've got a lawyer, uh, the judge can order the other party to pay your legal fees. So that's if somebody lies to the court. If somebody commits fraud outside of court, there's a whole lot of other different laws that could apply. Fraud is, a crime, among other things. So it would get very complicated very quickly. What kind of fraud? How did they do it? How many people were involved? Things like that.
Um, oh, I also just remembered. So I looked into the 2009 issue, and I think I had misremembered. It wasn't that it was rolling. It's that a building that was built before 2009 is exempt for 30 years.
Oh, okay. Right. Got it. So in 2040, we're all going to party.
It's going to be. Although, does the good cause law, does it expire at some point?
I'm sure it does because pretty much every law passed by a legislature or Congress expires. Uh, will have a sunset date with the assumption that it'll get renewed. Rent
Okay.
stabilization expires every once in a while. Yeah.
Yeah. Well, uh, except 2019 was so exciting in that it took away the sunset. And who knows, maybe if there is a sunset date for good cause, maybe that will be a reason for people to rally together to
Mhm.
renew it,
Yeah.
make it better. Let's see, another question came in. Under good cause, are landlords required to provide a 12-month lease renewal, or or can they say, I will keep you as a month-to-month tenant? And maybe there are actually two questions here. Maybe you could answer that one first.
Can they keep you as a month-to-month tenant, or do they have to give you a lease?
Yeah,
I'm trying to think. I'm sorry. I'm not sure that I have that. I might have to add that to the list of things I'm going to get back to you on.
because in the carve outs for good cause, if the tenant refused to agree to reasonable lease modifications,
Hmm.
um, so I mean, they must be assuming that there is a lease renewal.
Yeah.
But yeah, I feel like I've wondered this too. Um, yeah, and then the next question that this person had, what is the possibility that good cause will be renewed after its sunset date?
Um, I don't know. It depends what world we're living in when that comes along. Um, I mean, more broadly, right? Like, rent stabilization got renewed a bunch of times, even though, you know, landlords and real estate developers who are a very, very powerful lobby hate it because once once a set of rights and protections has been around and it's part of people's lives, it's politically really hard for legislators to take it away.
Yeah, and I guess because it's a bit of a political world crystal ball type of thing, um, we can't necessarily control everything about the future, but we can control what we do to try to organize to create the conditions for its renewal.
Yeah.
So, I mean, what better reason to get involved in the tenant movement? Um, to be involved in a neighborhood group, to be involved in a statewide group, like Housing Justice for All or the Right to Counsel Coalition. Um, and additionally, this law, it had a particular form when it was written in 2018, 19. Um, and that's not the form that it has today. And that's because there was a political fight that went on for 5 years. But laws can also be amended. And if enough tenants are politically motivated to band together and fight, it's possible to change laws.
Yeah.
Yeah.
Yeah, that is very, very true. Every law that we have that is good for tenants from the tiniest to the biggest is only there because tenants fought for it. Legislators are not sitting around in Albany trying to think of the next thing they're going to do to help tenants.
I might go back. There was a question about a rent stabilized apartment that might as well get back to. Uh, okay, what can a tenant do if they have three DHCR rent abatement orders or rent reduction orders, and the landlord is not complied and keeps sending lease renewals with rent increases?
I think that's a question about rent stabilization.
Yeah, it's a rent stabilized apartment. I just thought,
Um, yeah, I mean, if we have time, I'm happy to answer that. The first thing is that even when there's rent reduction orders in place, the landlord can the renewal leases can still show a rent increase. It's just that they can't charge that to you. Another way to think of that is, the legal rent, which is the maximum that they're allowed to charge under rent stabilization, that maximum can keep going up. It's just that the landlord can't collect the increase until they clear all the violations. So you get like two numbers. One is this sort of like ghost number, this hypothetical number about how much the landlord could charge if they fixed everything. That goes up, continues to go up. It should, that number should appear on the lease under legal rent. Um, but until they clear those rent reduction orders, the amount you pay out of your pocket every month will stay the same.
okay, that makes sense. Thank you for the question, um, and the answer. Uh, oh, does the landlord have to provide a lease renewal or a completely different contract to the tenant after their unit becomes destabilized when the 421A abatement expires? Um, and now I'm realizing 421A is another law that has had many evolutions throughout time. I don't know when 421A started. And in fact, 421A, they don't have it for new buildings anymore.
Yeah.
Um, it's now something else, but yeah, like I guess with Jesus's question, let's maybe assume that this unit um is covered by good cause.
Um, Probably. I mean, most buildings covered by 421A are big. Um, you know, Developers, it's not really worth going into that program if you're building a 3 unit house. So if it's big and it was built before 2009, and it's not covered by any other kind of regulation, right? You don't have like low income housing tax credits or Section 8, then you would be covered by good cause, yes. And the question in general, when 421A expires, um, if the landlord would continue giving you leases, there's no other kind of agreement. They would be no longer rent stabilized leases.
Yeah, but in that situation, having good cause as a sort of safety net as you're walking out onto that tightrope could be pretty
Yeah,
valuable.
exactly.
Um, and I think we got to this question earlier. Can the landlord increase the rent by 3% every month if they're a month-to-month tenant? Um,
Yeah, they not under good cause. That would add up to much higher than 8.8% by the end of the year if they were compounding 3% rent increases 12 times. I'm not sure how high that would be, but it would be more than 36%.
um, oh, and another question that has come up among buildings on rent strike is what if the what if a building has a small landlord and it wasn't covered by good cause while owned by the small landlord, but then the building goes into foreclosure and then gets taken by a bank. If a bank is the landlord, banks, I imagine, would own a lot of buildings. Like
Yeah,
they would own all of the buildings that they took after a foreclosure. Um, I don't know if you have some insight to
yeah,
share on that.
yeah. That could get you into good cause. Yeah. I mean, banks try to own the building for as short a time as they can. Um, and the bank might create an LLC to own it too. But yeah, I mean, uh, I think, yeah, I think if a bank owns your building, there's a pretty good chance you're covered by good cause.
So the bank could own an LLC, and then, I mean, all the more reason to figure out who's behind the LLC,
Yeah.
and then,
And this starts to get into the weeds of what happens during foreclosure and whether the foreclosure results in a short sale, whether the foreclosure ends in an auction, whether the foreclosure ends in the what's called real estate owned REO, which is the scenario you're describing where a bank owns it until
mm,
they sell it to somebody.
right.
It's also possible that you weren't covered by good cause because your landlord was a small landlord and then a big landlord buys your building and now you're covered by good cause. And it works the other way too. This is all assuming that you don't have 10 more than 10 units in the building.
And another question that I know that I've got about good cause, what has to do with, I mean, I guess going back to the ownership structures, um, uh, what if a landlord has ownership of your building transferred into a family member's name, like their wife or their brother? Um, uh, is this a legit way for them to escape good cause protections for their tenants? Or can tenants do anything when the landlord performs an
Um,
operation like that?
so the scenario would be, let's say I'm a landlord, I own, 500 housing units in New York. So I take your building and I change it, I put it in my daughter's name. Um, that would be enough to defeat good cause, but there's actually a good reason why a landlord is very unlikely to do that, which is when you put a building in an individual person's name, that person is individually personally liable for any kind of legal claim around the building. right? So if I did what I just described and then someone falls down the stairs, they can sue my daughter personally for that. That's why landlords put buildings in LLCs in the first place. Um,
Yeah, thank you. Had another question. So a follow-up to Jesus's question. If a unit becomes deregulated after expiration of J51 or 421A, but the tenant remains in the unit, does the landlord need to provide a renewal lease as to as opposed to a lease that doesn't specify whether it is renewal or new tenant?
I think I understand the question there, uh, that it's coming from under rent stabilization. There's an important difference between a renewal lease, right, when the same tenant is staying in the apartment, or a vacancy lease when a new tenant comes in. And all kinds of rules are different for those two things. But outside of rent stabilization, and this includes good cause, there actually aren't any important differences between those leases. Um, a lease is a renewal lease as long as it's the same tenant.
Mm, okay. Took me a while to understand that, but yeah, thank you.
Um, yeah, then it's possible I wasn't being clear. I think that the quickest answer to Ryan's question is, um, if if the same person is staying in the apartment from one lease to the next, then by definition it's a renewal lease.
Okay. Mm. Um, ooh.
Yeah,
Have there been any rulings on a discovery motion related to an LLC member's other holdings if the building is considered small?
thanks, John. John Gorman has been a tenant lawyer for a really long time, and I saw you join, and I was waiting for you to ask a question. I don't know, and if anybody else on here knows, that would be great. I think that my opinion as a lawyer is that if you is that judges would be inclined to grant a discovery motion on that. And for people who are not lawyers, discovery means in a lawsuit when you can make the other side hand over information to you that's that you might need in order to, in order to litigate the case. In housing court, you don't automatically get that. In other courts, you do. It's just part of a lawsuit. In housing court, you have to show the judge that you have a need for it. Um, and this, the number of units owned by your landlord would would seem to be like a prime example of information that you have need of and only your landlord has, and that therefore they should have to hand over to you. So I'd be pretty optimistic that judges are going to grant those motions. But again, it's housing court. So lots of things happen that aren't fair and that don't make sense.
Yeah, and how many tenants are going to know that they could even ask for discovery, or when you're allowed to ask for discovery, or how to successfully?
Yeah. Hmm.
Another thing why we need
I mean,
more tenant lawyers available for tenants.
yeah, I mean, this absolutely goes to the importance of the right to counsel. This is an incredibly complicated law, that doesn't have simple ways to resolve disputes. It just makes it even more difficult for people without lawyers to use the law if they're in court.
We've got another question. Um, do landlords need to have 10 or more units in NYC, or what if they have other properties out of NYC?
It's New York State. As long as it's in New York State, it counts. Outside of New York State doesn't count.
Um, oh, and along with that, I've heard that Acris has property registration information for properties in all five boroughs except for Staten Island. Um,
I have to say, it's been a long time since I've looked up a property in Staten Island. Um, but that would be easy enough to check.
yeah, and maybe it's a reason to get on the Staten Island ferry and go to the county clerk's office to look it up.
Or
Uh,
join my campaign to give Staten Island back to New Jersey.
oh
Sorry,
no, we're going
anybody
to get
in
canceled.
Staten Island.
Um, yeah, and maybe this wasn't asked, but I imagine that a lot of tenants might wonder because there might be some people in the audience who, um, tenant organizers think, okay, I need to prepare myself to do this sort of research. Legal service providers are prepping to do the research, but maybe, I don't know if you're an HRA employee or you work at home base, you might not be sure about going on that journey. Oh, Staten Island is included in Acris. Yes.
Yeah, I just looked. Yeah.
Perfect. Okay. Uh, so, uh, what are sort of the range of places where a tenant could potentially get help doing this research if, if they're just completely bewildered by all of this?
Sure. Well, I guess one would be Housing Court Answers. I don't want to volunteer you all, but you seem like a really valuable resource to tenants who are in the position, people hopefully people on this call will, proactively look up your building, help other people do it. But a lot of tenants are going to first encounter this question when their landlord says, I'm not renewing your lease, or when they're being taken to court. And Housing Court Answers is just, it's always just been so crucial that you are there for people in that moment. Um, Other places people could go, I mean, there are a lot of community organizations in New York that organize tenants or do advocacy for tenants, and those are usually based around certain neighborhoods, so it would depend on what neighborhood you're in. But there are, places like the Fifth Avenue Committee or Impact Brooklyn or Cooper Square Committee, um, or
CASA in the
Goals,
Bronx, Northwest
CASA,
Bronx
Northwest
Community and
Bronx, yeah.
Clergy. Yeah.
Um, you can also try legal services offices like ours. Most legal services offices will have advice hotlines, um, which may not be the ideal place. This might not be the kind of research you want to do with somebody live on the phone. But I imagine that most nonprofit legal services organizations are thinking about how they can help people with this particular kind of research.
Also, I mean, legal clinics might be,
Mhm.
and legal clinics can be throughout the city, and it's just a question of figuring out are you in a neighborhood that has them? Um, some elected officials have legal clinics, on a regular basis, and if
Mhm.
it's specifically a housing lawyer, they at this point they would probably have the experience to look into it. I mean, an immigration lawyer probably wouldn't have ever heard of good cause. So, you'd
I,
have to, yeah.
I also think, every elected official has constituent services people, whether they're a council member or a state senator or a assembly member, federal, um, and this this is very likely to be on their radar and very likely to be something that they're developing their skills at. So you may be able to call your local elected official and have somebody in their office help you access these websites and do the research.
Yeah. Um, so I don't see any new questions in the chat. Oh, uh, oh, John put a message, had a case involving a 10-unit building. The owner recently transferred title to a Delaware LLC.
And that's not going to help them, John, because under the good cause law, you look at not only what the LLC owns, but what the people behind it own. So it's still going to be any unit that's connected to the person or people behind that Delaware LLC.
So, yeah, I just want to give a giant thank you to Michael Gridthal from Take Root Justice for giving this presentation. Anybody who joined us a little bit late, please check out the recording of this, which will appear on Housing Court Answers' website. Nipa had put the link into the chat a little bit earlier. Oh, thank you, Nipa. So thank you, Nipa, for doing tech. But yeah, thank you everybody for being here. Please keep talking about good cause with everybody who you think might benefit from knowing this. And really any unregulated tenant should hear about this, should know about, should think about it. More answers might come later. Yeah, Michael, did you want to say anything?
I wanted to thank everybody, first of all, for letting me ramble on, but I also want to thank everybody for all the work that I know you're all doing, whether you are staff at an organization or an agency, or whether you are a tenant advocating for yourself or advocating for your family members or your neighbors, the organizing you're doing just by being here, you are part of the tenant movement. And I hope that